Photographs. Thank you very much.
All right, on that note, we're going to get started. Thank you all so much for being here. It's great to see such an incredible turnout, standing room only, although we have a couple seats in front if anyone wants to sneak in front before we get started. So welcome to our first Human Rights in Practice event of the year, the Human Right to a Healthy Environment, organized by the International Human Rights Clinic and the Center for International and Comparative Law. We are very happy to have with us today Professor John Knox, Henry C. Lauerman Professor of International Law at Wake Forest University School of Law. Professor Knox is an internationally recognized expert on human rights and the environment and international environmental law. From 2012 to 2015, he served as the United Nations independent expert, and subsequently from 2015 to 2018 as the first UN Special Rapporteur on the issue of human rights obligations relating to the enjoyment of a safe, clean, healthy, and sustainable environment. In that role, he submitted a series of reports to the UN Human Rights Council on the application of human rights law to environmental issues, including climate change and the conservation of biological diversity. In 2018, he concluded his mandate by presenting framework principles on human rights and the environment to the UN and by calling on the UN General Assembly to recognize the human right to a healthy and sustainable environment. Professor Knox will discuss some of this work as Special Rapporteur, including initiatives on climate change and human rights, as well as a call for the global recognition of the human right to a healthy environment. Before turning it over, I wanted to thank all of our co-sponsors for today's event, the Duke Environmental Law and Policy Clinic, the Duke Environmental Law Society, the Duke Human Rights Center at the Franklin Humanities Institute, the Duke Human Rights Center at the Keenan Institute for Ethics, the Human Rights Law Society, and the International Law Society. I also wanted to make a quick announcement on behalf of Elsa Haig, who is sitting in the second row here, very relevant to today's topic, which is that there is a newly established network at Duke, the Duke Environmental Justice Network. And the goal of the network is to connect members of the Duke community across graduate and professional schools and to provide opportunities to engage with different environmental justice issues. It is led by students and faculty in law, economics, engineering, environmental policy and management, public policy, and public health. And Professor Longest, one of the directors of the Environmental Law and Policy Clinic, also with us today, is one of the faculty advisors to the network. If you have an interest in environmental justice issues, Elsa would love to encourage you to sign up for the listserv, which you can do by scanning a QR code posted just outside the door or by talking to Elsa. And with that, I will turn it over to Professor Knox. Thank you.
All right, thank you very much, and thank you all for coming here. I really appreciate the opportunity to speak with you today. It's a pleasure to be at Duke, where I know some people, and I know Larry Halpern in particular for a very long time. We were talking about how we've known for 20 years, which is hard to believe given our youthful good looks, but we met in, kindergarten or something. But, all right, so I'm going to talk about the human right to a healthy environment. I'm going to try and organize this according to three basic questions. First, does a human right to a healthy environment already exist? And I'll give you a spoiler alert. The answer is kind of yes and no. Second, what do other
You're being recorded, and if you're not standing either here or with a mic, we can't get audio.
Oh, okay. Is this good? Am I okay now?
Just got to turn it on.
Just turn it on. Yeah. Okay. All right. Okay. I won't start over again, even though the most important things I've already said, so I apologize to people who are listening to this on the recording. But I'm going to go through these three questions. First, does a human right to a healthy environment already exist? Second, what do other human rights have to say about environmental issues? And it turns out the answer is quite a lot. And then third, should the United Nations recognize for the first time formally a standalone, autonomous human right to a healthy environment? So let's kind of go through these one at a time. So first, the first question, as I already said, is does the human right to a healthy environment exist? Yes, but also kind of no. So it depends on what level of national, regional, and global systems we're talking about. Let's start with the beginning. When we talk about human rights, it's always good to start with the basics. So in 1948, the General Assembly adopted the Universal Declaration of Human Rights. It was drafted by the Human Rights Commission, chaired at the time by Eleanor Roosevelt. There she is looking proudly at their work. The Universal Declaration includes a number of basic human rights that have since been incorporated into binding international treaties. They include not only the kinds of rights we see on the left-hand column, so-called civil and political rights, like rights to life, liberty, and property, that American law students in particular are comfortable with because you learn about them as part of our Bill of Rights. It just seems like those are the real human rights when we talk about human rights. But the Universal Declaration also includes so-called economic, social, and cultural rights, rights like a right to Social Security or labor rights, rights to education, rights to an adequate standard of living. What it does not include, and you can look at it as a word cloud or however else you want, it doesn't say anything about the environment. This is not really because Eleanor Roosevelt just forgot. It's because the whole concept of the environment was simply not really on the agenda of people drafting human rights declarations in 1948. The modern environmental movement really got off the ground in the 60s, and so by the time the modern environmental movement got off the ground, the human rights kind of framework instruments, both the Universal Declaration but also the international covenants on civil and political and economic and social and cultural rights, already had been adopted. So in a sense then, the idea of a human right to a healthy environment could be said to have kind of missed the bus. But that's only at the United Nations level. At the national level, many national constitutions, beginning in the 1970s, began to incorporate a standalone, free, a new autonomous human right to a healthy environment. Now it's continued ever since. So now there are at least 100 constitutions around the world that specifically refer to some variation of a right to a healthy environment. About 2/3 actually refer to the word health in some way, but others refer to an ecologically balanced environment. Others refer to clean, safe, favorable, wholesome. But all of them have in common this idea that a right to a fill-in-the-blank environment is one of the fundamental rights that those countries recognize. Also, at the regional level, regional human rights and environmental agreements nearly always include a right to a healthy environment, again, with some variation in the language used. This is because, probably one might conclude, these agreements came along after the modern environmental movement had really flourished. And so starting in the 1970s and through the 80s and 90s, agreements at the regional level that have been negotiated nearly always include some reference to, again, some variation of a right to a healthy environment. So when you put all this together, that is the rights that are included, the countries that include the right at the national level or the regional level, you get to a very large proportion of all the countries in the world. Of course, there are some important countries that still aren't on board with it, and they include our own country, the United States, but also Canada, Australia, China, Japan. These are fairly influential countries. Nevertheless, there have been efforts at the United Nations level since the modern environmental movement really began to take off to include a right to a healthy environment in some kind of global UN document. The most successful effort was right at the very beginning. The Stockholm Conference of 1972 was the first major international environmental conference, and it started off, its very first principle says, man has the fundamental right to freedom, equality, and adequate conditions of life in an environment of equality that permits a life of dignity and well-being. Putting aside the kind of outdated gendered language here, the idea here is that, that basically looks like a human right to a healthy environment. That's as close as the United Nations or any global conference has ever come, though. 20 years later, at the time of the Rio Declaration, or the Rio Conference, that was at the time the biggest conference ever, and still is one of the biggest ever held, it also included in its very first principle a kind of echo of the Stockholm Declaration on this, but notice that it replaces the word right with the word entitled to. It's almost as if someone had written they have the right to a healthy and productive life in harmony with nature, and then someone else had said, well, we don't really like the word right. That someone might possibly have worked for the U.S. Department of State, I speculate. even though I was, in fact, working for the U.S. Department of State at the time, it was not me who did this, but I do know that this was the position of the State Department at the time. The U.S. government was simply against the idea of a recognition of a right to a healthy environment. So even though you could say this is synonymous, it's not really, because they are entitled to simply doesn't draw on the same history, the same kind of ecosystem, so to speak, of human rights. So this is as close as the United Nations has come. Now, the Stockholm and Rio declarations were out of, you might say, the environmental side of things. But there were also efforts from the United Nations human rights bodies. The most, again, successful effort at the time was in the Human Rights Commission, the same body that Eleanor Roosevelt had chaired 40 years earlier. A woman named Fatma Centini was appointed by a subcommission, an expert group under the Human Rights Commission, to study human rights and the environment. And she did a series of reports which culminated in a proposal for a declaration on human rights and the environment, which would have included a right to a healthy environment. The Human Rights Commission, which is composed of government representatives, again rejected the proposal, and the rejection was led by, again, the United States and the United Kingdom. I've joked about this, but it's kind of true. I actually was working on human rights issues at the State Department at the time. That's not the joke. But I had the Human Rights and Environment file in the early to mid-'90s for a while, and here's the joke. The joke was that the file was really thin. It only had one page because the file said on the outside, human rights and the environment. You opened it up and said, there is no human right to a healthy environment, and that was all you had to know. You closed the file, and that's kind of true. I mean, our position was there was nothing to talk about here. There simply is no such thing as a human right to a healthy environment. So that's kind of where things continue to stand at the international and national level. There's been widespread adoption of a right to a healthy environment at the national and the regional levels, but not at the United Nations level. And much of the reason for that is because it's been opposed by powerful countries, including, most importantly, the United States. So, what about other human rights? What do other human rights say about the environment? You could say blocked by this inability to get a standalone human right to a healthy environment adopted at the United Nations level. What did human rights and environmental advocates do instead? Well, what they did is turn to human rights bodies and bring claims arising from environmental harm, but alleging that the environmental harm interfered with the enjoyment of a vast range of other rights. Rights to life, rights to private and family life, rights to property, rights to water, and so forth and so on. Who did they bring them to? Well, unlike international environmental law, which really doesn't provide many opportunities for individuals and communities to bring claims, human rights law, human rights institutions provide a lot of those kinds of opportunities. They're weak, they're ineffective in many ways, absolutely, but at least they exist. So you can bring a claim to, for example, the Inter-American Court of Human Rights, which is that picture on the left there, which is based in Costa Rica. You can bring a claim to special rapporteurs appointed by the Human Rights Commission, which along the way has now been replaced by the Human Rights Council. So these special rapporteurs can receive communications, issue reports, and essentially apply human rights law to your situation. So between the regional bodies and the United Nations human rights expert bodies, they began to create this really far-reaching jurisprudence, this kind of human rights and environment jurisprudence, which applied, again, rights to life, privacy, property, water, health, and so forth, and created a lot of, let's say, law, environmental human rights law, even though, again, they're not applying the standalone human right to a healthy environment. So years go by, this law develops, and in 2012, the Human Rights Council returns to the topic. And I can, if you like, in the questions, I can go into more detail about what exactly the politics were that enabled them to reach the outcome they reached. But the bottom line is they decided to appoint for the first time an independent expert on human rights and the environment. Now, I've already referred to special rapporteurs. Let me say a word about kind of how that whole system works. The Human Rights Council, and by the way, this is an actual picture of the Human Rights Council's room in the Palais des Nations in Geneva. This picture doesn't even really do justice to the ceiling of the Human Rights Council. I encourage you to kind of take a moment at some point to really focus on the ceiling. It looks like it's falling in a very multicolored, almost hallucinogenic way. It looks like it's a bunch of I always get them mixed up. What are the, not stalagmites, stalactites, right? That are, because they hold tight to the ceiling, that's it. So the it looks like a bunch of stalactites might fall at any moment on the people in the room. And at first this really annoyed me, and over time, I not only became comfortable with it, I really liked it. It's a multi-million-dollar piece of art, but that's not so much why I liked it. It's kind of soothing to look at, and that helped. But it also, sometimes debates in the Human Rights Council can go on and on. And so it's a way of kind of relaxing your mind by thinking, okay, if the French delegate doesn't shut up much longer, I'm going to think about where would that stalactite actually fall if it were to fall. Maybe it would take out the French delegate. That's, I mean, nothing against the French in particular. But anyway, so the council is, as you would expect, composed of government representatives, and they find it difficult to criticize one another. Governments always get uncomfortable when they criticize each other too much. They still do sometimes, but it's uncomfortable for them. So there's always a kind of this inherent weakness in how the council operates. However, the council does do this pretty cool thing, which is appoint special rapporteurs, independent human rights experts with mandates to go out and to do investigations, receive communications, issue reports. And these reports can be on whatever the mandate of the Human Rights Special Rapporteur is. So special rapporteurs can be country-specific. There are special rapporteurs on Myanmar, North Korea, and so forth. But they can also be thematic. And the thematic rapporteurs can be on particular rights or particular kinds of problems. So there's a special rapporteur on torture. There's a working group on enforced disappearances. There are special rapporteurs on the right to water, the right of freedom of expression. In all, there are about 50 of these mandates. What there had never been before was a mandate specifically on the environment. And so the Human Rights Council, when it's entering into a new area, sometimes what it does is instead of appointing a special rapporteur, it appoints an independent expert to basically say, look, we don't really know exactly enough about this area yet to be able to tell governments this is what you should be complying with. Again, special rapporteurs are about comply with the law. But what if we don't know exactly what the law is? So occasionally the council will appoint an independent expert. They've done it in recent years on the right to water, on business and human rights, and in my case, they did it on human rights and the environment. So the mandate that I was given, because I was appointed to this position a few months later, was to study the human rights obligations relating to the environment and to identify best practices in their use. Not so much to receive communications, not to go on country visits. That would be a little bit more controversial, but just tell us what's going on out there. So to that end, I held consultations in every region of the world. With the help of a lot of students and lawyers and law attorneys working pro bono and academics, I basically I did a series of 14 reports that tried to map everything human rights bodies had said about the environment. I also looked at some international environmental instruments to see what they were saying about the environment. So I'm sorry, about human rights and the environment. So as the result of all this, I actually found, and all this is available online, it's all publicly available. What I found was you could actually summarize the conclusions pretty briefly. First, basically every human rights body that had looked at environmental issues had concluded that, yeah, absolutely, environmental harm can interfere with the full enjoyment of human rights, a vast range of human rights. We've already kind of touched on that. But they didn't stop there. They also said, as a result, states have obligations under human rights law to protect these human rights from environmental interference. And these obligations include procedural types of obligations, but also substantive standards, and they have additional or more specific obligations with respect to those who are most vulnerable, most at risk from environmental harm. So I issued a report on this, and then I issued a report on best practices, and in 2015, at the end of my 3-year term, the council decided, okay, we're going to renew your term for another 3 years, and we're going to add these new things to it. Now we're going to, in addition, we're going to tell you to go ahead and keep studying and identifying good practices. Nothing ever gets taken away from a mandate. But we also want to tell you to promote and report on the realization of these human rights obligations and to work on identifying challenges and obstacles to their full realization. The Human Rights Council doesn't like to use the words violation and compliance very often, but that's what they're really talking about. So in other words, the mandate was switched to look more like the vast majority of the other mandates. I became a special rapporteur with a mandate to go out and promote compliance with these obligations. So I sometimes was asked after this, so did you feel like you got a promotion? And being kind of smart alecky, I guess my initial reaction would be to say something like, well, I wasn't getting paid to begin with, so I'm not getting paid anymore now, so it doesn't really feel like that kind of promotion. But yeah, for the mandate, it was a promotion because the council indicated that it does believe that these human rights obligations are firm enough that it's fair to hold governments' feet to the fire about them, that it's fair to hold governments to these standards. So in that sense, absolutely, it was a promotion for the mandate. So over the next 3 years then, my second term as the mandate holder, I was on two tracks in a way. I continued to issue reports that tried to clarify how human rights norms apply to specific environmental topics. I issued reports on climate change, for example, on biodiversity and human rights, and children's rights in the environment. But I also spent a lot of time trying to promote implementation and compliance with the norms that had already been established. And so to that end, I did things. I went on country visits, I received communications, I started an online course, I did a lot of work with environmental human rights defenders. And then as you heard, as Aya said, in my very last report to the council, I submitted so-called framework principles on human rights and the environment. So I'm going to spend a couple of minutes just talking about them. So these are the framework principles. This is my prop for my lecture, so you can see what they are. This is not how UN reports normally look. I got a human rights organization, basically the Raoul Wallenberg Institute, said, we'd like to make this look a little bit more palatable. It turns out not everybody reads UN reports. Who knew? So maybe if we put pictures in it and stuff, then it'll be more readable. And I think that's a good idea. So, but anyway, so the framework principles were presented. I presented them to the Human Rights Council in 2018, and I'm just going to take you through them briefly. So the first two express this kind of mutually beneficial reciprocal relationship between human rights and the environment. That is, you have to have a healthy environment in order to be able to enjoy your human rights, but also you have to be able to exercise your human rights in order to be able to work to have a healthy environment. So in this sense, there's this kind of hopefully virtuous circle in which the better the environment is, the better you can enjoy your human rights, but also you can better use your human rights to protect the environment. Of course, it does not always work that way. So states have a lot of pretty well-defined procedural duties. Despite the fact that these human rights bodies are interpreting different human rights agreements, they come to very similar conclusions. States have obligations to protect environmental defenders. That may seem kind of obvious. They have obligations to protect freedom of expression and association in the environmental context, promote education, make environmental information public, assess environmental and human rights impacts, facilitate public participation, and provide for remedies. Some of these may seem like, well, aren't we just saying they have these obligations generally and they include environmental issues? And in some cases, that's basically true. Of course, you have the right of freedom of expression and association. Of course, it therefore should apply when you're talking about environmental issues. Some of them are less obvious. There's not really a standalone right to have things assessed. But many, many human rights bodies have said that prior environmental impact and human rights assessment is necessary in order to be able to protect human rights from environmental interference. Governments have to, in other words, look first before they go ahead with something that might interfere with might cause environmental harm that in turn violates human rights. Substantive standards, human rights bodies are much more deferential to governments, whereas procedural standards, they are willing to get pretty specific. For substantive standards, they recognize that it's not reasonable to expect Ghana, say, to have the same level of environmental protection as Germany or Denmark. Having said that, they are willing to impose some substantive standards. They're willing to let governments strike a balance, but the balance has to be reasonable. It has to be, it cannot be retrogressive. It has to move forward. You can't reset the balance to have a lower standard, a lower level of environmental protection. Obviously, it has to be non-discriminatory. And other factors that I haven't included on this slide that human rights bodies and courts have taken into account include things like, are you, government, taking into account the best international standards? Are you taking into account what, for example, the World Health Organization says about exposure to levels of air pollution in setting your own standards? Are you reaching these standards through mechanisms that allow people to participate, that provide protection for environmental defenders and so forth? Because if you're not, then we're not going to defer to you. So this is not, in other words, completely toothless.
as a level of review at the human rights level, but it is definitely more deferential. And then once you have these standards in place, human rights bodies say you've got to effectively enforce them. You simply cannot allow them to only exist on the books. What about transboundary and global harm? This is, again, we can get into this in the questions if you want, but this is a more, let's say, difficult issue in human rights law, the whole question of extraterritorial obligations. But I said in my reports that states do have an obligation of international cooperation to deal with global problems such as climate change and the global loss of biodiversity, and I got more specific about what that meant for states. So yes, states do have this obligation under human rights law as well. And then finally, states have obligations not to discriminate. Again, that seems like a fairly self-evident one, but it's one that is often violated in the environmental context. Many types of environmental harm have discriminatory effects. Governments very rarely take into account those discriminatory effects or the discriminatory effects of their own actions in dealing with purported environmental problems. And to be clear about this, this is one in which it doesn't matter your level of economic or social or anything else development or what other challenges you have. You can't discriminate under human rights law. You can't say, well, our country is developing, our economy needs some room to grow, and so therefore this minority group, we're going to leave them behind. That's not how human rights law works. So you have obligations to take additional steps to protect those most at risk. And in particular, indigenous peoples and local communities' rights are actually fairly well defined now in human rights law, although they're often violated. And so often those rights are particularly relevant to environmental protection because those are the communities and peoples that live most closely to and most depend on natural ecosystems. And then finally, states have to respect these rights when they're carrying out their programs for sustainable development. What that means is essentially states can't say, well, we know we have all these human rights obligations, but you know, this dam has to go forward because it's a renewable energy project. And therefore, we kind of you need to cut us some slack on the fact that we're going to have to violate so-called human rights. That's not how this works either. You can't say, well, we're doing this for a really good cause, therefore kind of overlook the fact that we're having to displace people from their ancestral home, and we've had to shoot a few people or arrest them when they protest. That's not how human rights law works either. So after all this, at the end of my second and last term, you can only serve 2 3-year terms, I presented this report to the council, and the council unanimously, all the resolutions on this have been unanimous actually, took note with appreciation of my report. That's a kind of lukewarm, didn't welcome. This is totally negotiated, I can tell you. Like hours and hours are spent negotiating what that verb is, whether it's take note or take note with appreciation. And the reason is because the United States wasn't happy again, and a few other countries weren't. But on the whole, it was a success that they actually got to refer to the framework principles in the preamble of the resolution, that they continued the mandate. The new mandate holder's name is David Boyd, who's a professor at the University of British Columbia. And for the first time, they asked the new mandate holder to report to the General Assembly. David's going to make his second report to the General Assembly in October of this year, just next month, in addition to reporting to the Human Rights Council. So that brings me to the third question, which is, should the United Nations recognize the right to a healthy environment? And again, spoiler alert, you're probably not surprised to hear me. What would if I said no? You'd all be like, wow, that is unexpected. No, of course they should. Of course they should recognize the right to a healthy environment. And I said that in my last report. And in my really, really last report was one I co-wrote with David that was his first report to the General Assembly. Because of the way UN reporting rules work, I had to write the report and submit it before I left, and then David had to actually present it. So we co-wrote it. In that report, we basically urged the General Assembly to adopt a human right to a healthy environment. The General Assembly has kind of informal rules that you should meet before you do things like just announce that there's a new human right. They were included in this resolution that GA adopted back in 1986. I think they're all pretty reasonable standards, and I think the right to a healthy environment obviously meets all of them. Is it consistent with the existing body of international human rights law? I can say that is what I spent basically all 6 years of my mandate showing. Is it a fundamental character and derives from the inherent dignity of worth of the human person? You simply cannot enjoy your other human rights or a good life if you're living in a polluted, degraded environment. So, yes. Is it sufficiently precise to give rise to identifiable and practicable rights and obligations? Many people historically here have used this as their criticism of the human right to a healthy environment, including scholars, mainly Anglo-American scholars. I just think that's been disproved. These 100 countries that have adopted it into their national constitutions have produced thousands of decisions. Not all of them. Some countries just kind of hang it up like you, I don't know, put up a decoration on the wall and then kind of ignore it. But in many countries, courts issue dozens of decisions applying the human right to a healthy environment at the national level, at the regional level, and now at the United Nations level. It has given rise to identifiable rights and obligations. So, yeah, that one I think is done too. Has it attracted broad international support? Very broad, except for just a few countries. And then I skipped over realistic and effective implementation machinery, including reporting systems. It's no worse on this than any other human right is. I mean, again, these mechanisms are all ineffective, but there's no reason to think that they would be somehow more ineffective or less effective when we're talking about the environmental context. So, yeah, of course, these are all met. David Boyd, my successor, my field was more international human rights law and international environmental law. David's was very much like at the national level. He's literally written the book on the spread of the national human right to a healthy environment. And in his book, he has identified all of these benefits that a right to a healthy environment has shown at the national level. I won't go through all of them. I know I want to leave time for questions, but let's just say there are a lot of people who have looked at this and said states are better off environmentally when they have this right. So how would you do it? Well, one possibility would be a new treaty. Last year, the Global Pact for the Environment, some of you may have heard of that, was proposed by France. Its first article would have recognized this. It was shot down in negotiations over the last year. Which country led the opposition to it? The US of A. We're number one. The second possibility would be a protocol to an existing treaty, and the third possibility would be a UNGA declaration or resolution. David and I think pretty strongly that the best way to go is a declaration or resolution, for the simple reason that we're just not going to realistically see a treaty in the coming years. It's just going to take too long, be too easy to stop. It's too easy for countries to stop it. But a declaration or even just a resolution, there are models for that. Remember, I mentioned the right to water. The right to water, like the right to a healthy environment, is not included in any of the major human rights documents. It's not in the Covenant on Economic, Social, and Cultural Rights, even though the right to food and housing are. So beginning in around 2006, the council did things like appoint an independent expert. She issued a series of reports. Her name was Caterina de Albuquerque, or still is Caterina de Albuquerque. And as a result of this, the GA just said, you know what, we think there is a right to water. There are a few countries that abstained or voted against, but on the whole, that was accepted. I think the General Assembly could pretty easily just do the same thing for the right to a healthy environment. What would a new right add to existing rights? I actually have a book. It's available for purchase. It's only $20, $25, very reasonable. Anyway, Ramin Pajan and I edited this book with essays that address this question. I think you could sum them up by saying one thing it could do is kind of serve to integrate, to pull together this extensive body of human rights law under one simple, easy to remember umbrella. It's nice to be able to come here and listen to me talk about all the ways human rights law applies to the environment. It would be a lot simpler, though, if we could just say, yeah, we have a human right to a healthy environment. And it requires that governments do the things that are in this pamphlet, this handout. But it could also go further, right? Some people would like to see it provide a cornerstone to build on which you could build other rights, like rights of future generations, something human rights law says just about nothing about right now. Or even rights of nature. Rights of nature, by definition, seems like a counterintuitive thing for human rights law to address. But there are efforts at national level, some were quite successful, to write rights of nature into law. This is the Whanganui River, which was the subject of a really important breakthrough in New Zealand law, where they said that Whanganui River has legal personhood, based in large part on the historical cultural views of the Maori people about the Whanganui River. So it's not as if it's unheard of at the national level. It may be a bridge too far right now at the international level, but that may be where the law is moving. That concludes my talk. I'm on Twitter. to the semi-horror of my daughters, I only tweet about human rights and the environment, not the Kardashians. So you're safe if you want to follow me there. I do really actually recommend Twitter for keeping up with human rights and the environment stuff. There are a lot of really great people working on this all over the world, and it just almost never makes the news. You just don't hear about developments in this area unless you're following people on Twitter who are working on them. So I do encourage you to think about that. And I'm happy to take any questions you might have. Yes?
Well, thank you for that. Is there, in practice, a forum where State A could complain against State B for actions that harm the environment with specific effects on that particular consequences of that particular state? Bring it.
Yes, there are. So the question, if you didn't hear that in the back, was basically, is there a forum in which State A could bring a claim against State B for environmental harm to State A? So historically, the answer to that has been that states could, for example, create an ad hoc tribunal. The most famous one in international environmental law involved the trail smelter dispute between Canada and the United States, which, even though it was decided in the 1930s and 40s, is still taught as a kind of cornerstone case in international environmental law textbooks. But there have been a lot of cases since then. Argentina brought a case against Uruguay to the International Court of Justice, complaining about pulp mills that Uruguay had allowed to be built that Argentina said violated agreements between the two countries. Australia brought a claim against Japan for essentially alleging that it was whaling illegally. So there are some opportunities. They have the kinds of problems that international legal dispute resolution often has. That is, they're not open to countries. Countries have to basically agree to be bound by them, which not all countries are willing to do. Again, this is something, though, that human rights bodies offer that other bodies don't. What I've just described, are not open to individuals. So I can't bring a case to the ICJ, but I can bring a case to a human rights special rapporteur, or if I exhaust my local remedies, I can get even to the European Court of Human Rights. So, so that's one of the real advantages of a human rights approach to environmental issues, is that it opens up avenues for relief that otherwise wouldn't exist, otherwise don't exist.
Has Europe been aggressive or?
The European Court of Human Rights has been, I would say, by far the most engaged body with these issues. Yeah, over the last 25 years or so. Questions? Yeah.
I have a question. Like you mentioned that there's kind of the duty of the state to kind of make the public participate in this environmental decisions. However, this is much more procedural, and I would say that somehow, even if certain communities, they do participate in those decisions after they actually participate, those decisions are not binding. So, for instance, in Ecuador, we had a case whereby there was this oil field that was supposed to be exploited, and after a while, the communities surrounding this oil field said, no, we don't want exploitation of those resources here because they will destroy the nature. And since this consultation is not binding, how is it possible that it's not a violation of human rights and of the right to a healthy environment?
So one principle of international human rights law that is particularly relevant or is developed particularly clearly in the indigenous context is the idea of free, prior, and informed consent. And this FPIC principle, as it's sometimes called, simply says that before an action is allowed or undertaken by a government in an area that has been traditionally occupied or depended upon or is important to an indigenous people, they have to not only consult with the indigenous people, but also get their free, prior, and informed consent. This is a controversial topic among governments, which don't like to give indigenous peoples or local communities this kind of control. And so governments often do pay lip service to the idea of consultation, just as you're saying, and then go ahead anyway, even if the community says no. That happens all over the world. And I would say it is a violation of human rights.
And can that be somehow important in certain court, let's say, like in the yes somehow?
So in the Inter-American system, the remedy, the regional body that oversees compliance with human rights most effectively in the Inter-American system is the Inter-American Commission on Human Rights and the Inter-American Human Rights Court, the Inter-American Court of Human Rights. And they have issued a large number of decisions basically holding that governments have violated the FPIC idea, the FPIC norm, I should say, by doing just what you've said. Now, governments don't always comply with that either. I mean, I don't want to leave anyone the idea that international human rights bodies are somehow, super effective, and when governments are told they're doing something wrong, they immediately bring themselves into compliance. It's absolutely not that way. All they are is better than nothing, right? They are, though, better than nothing. So the Inter-American Court and Commission, once they enter a decision like this, it does help create pressure on governments to comply with it. Is that always enough? No, it's definitely not always enough. But it's better than not having it at all. But that's the fight in many, many countries around the world. Communities are essentially having their own views about development overridden by the national government because it doesn't want to hear the local community say, no, we don't want this dam or this mine. And we want to go ahead anyway. There.
John, I wonder if you can just, you've talked about, and I share with you, relatively speaking, these mechanisms are better than nothing, but I think you could go a little further, right? So they do, even when governments don't immediately respond, they help to frame particular issues. They provide a focal point for legal and social mobilization. They sometimes get engaged with by national judges in national proceedings, which then are directly enforced at the domestic level, more or less. So I'm wondering if you, from your 6 years of experience in the work that you were doing, can identify an example or two where the kinds of norms you were articulating and the best practices that you were developing help to empower civil society or a local community or an NGO in a way that actually made a difference. Not to say that that's necessarily representative of all the other situations, but it'd be helpful, I think, to hear that.
Yeah, no, absolutely. And I don't want to make it sound like these things never make a difference at all. I don't think that is true. I think for one thing, you have to kind of just talk about what more specifically about what kind of institution you're talking about. So the European Court of Human Rights, governments are bound to comply with it, or at least to pay compensation. The European Court doesn't really order governments to comply. It's more like it says that governments have to pay damages if they don't comply. Nevertheless, governments take it seriously. They normally comply with decisions, and their decisions are having an effect. I mean, one example of that Larry's talking about the way that the regional and international bodies can influence national decisions is the Urgenda case, which I imagine some of you have heard about. But if not, let me tell you about it. The Urgenda case was filed by an organization in the Netherlands called Urgenda against the government of the Netherlands, claiming that the government of the Netherlands had violated human rights law, among other Dutch laws, by not taking quicker steps to reduce its greenhouse gas emissions. Just a year ago, the appellate court in the Dutch in The Hague said, we agree with you. And in fact, the government has to take faster steps than it's taking. And they base that on the European Convention of Human Rights and the jurisprudence of the European Court of Human Rights. I talked with an organization called Client Earth, which it's kind of an environmental advocacy organization that operates throughout Europe. I talked with them a month or two ago, and they said they know of 8 other cases right now that are being brought in Europe that are basically against France, Italy, Germany, along the same lines. So that's pretty good. Now, in other countries, it can also work that way. A recent decision by the Human Rights Committee, which is yet another body, it's the treaty body that oversees the International Covenant on Civil and Political Rights. So it's not the Human Rights Council, it's not the Human Rights Commission. It's another body, but it's composed of independent experts. They issued their first major decision on human rights as it applies to the environment. They were reviewing a case coming out of Paraguay, and they said that because Paraguay had done such a miserable job of protecting a local community from pesticides, resulting in the death of one of the members of the community and the illness of others, that they had actually violated people's rights to life and their rights to family and private life. So I tweeted about this, and I said something like, this is really important. We have to remember this is non-binding, but blah, blah, blah. members of the Human Rights Committee, the people who had issued the decision, current and former members, tweeted back to me and said, well, wait a minute, it is binding, or at least it's too simplistic to say that it's not binding. And I came back to them and said, how do you mean it's binding? And what I found out that I didn't know is several governments now, maybe more than several, have actually incorporated in their domestic law provisions that allow Human Rights Committee decisions to have direct effect, so courts can take them into account. So there's increasing kind of interaction, I would say, between the international level and the domestic level, and it can go both ways. I think we've seen the right to a healthy environment has been influenced at the international level by the domestic level, but it's also going the other way. So in addition to all the things Larry said, which are true, I mean, that gives you maybe some other ideas about how this can have this kind of effect. Yeah.
Hey, Jonathan, it's great
Oh,
to
hi.
have you.
Yeah, it's nice to see you.
Thank you, and those examples I think are really helpful. Because my question was somewhat in the spirit of Larry's as well. Partly to ask, in the near term or the longer term, and especially for students interested in how they can make the most difference, do you see this movement on human rights and the environment or this project as multifaceted as it is, as a political, social acculturation process that helps shape government policy decisions, and or to what extent you see it as a litigation, judicially focused strategy? And I'm glad you mentioned the Urgenda case and other cases like that, because and there are cases like that in the United States, the Our Children's Trust cases and the Juliana case. We have a case in North Carolina like that as well. And one of the objections that's sometimes raised to those kinds of cases is, well, it's good to have a better environmental protection, better climate change policy, but the judiciary is not the right institution to do that because these are large, complex policy problems. And you can see that the spirit of that objection also in some of the Supreme Court opinions, like Connecticut versus American Electric Power. And an interesting counter, another example of that is the Pakistani case, the Lagari case, where the court's remedy was not to tell the government you must adopt this climate policy, but to set up an expert body to try to come up with a climate policy, a kind of ad hoc administrative law process that I'm not sure if we have here. So, how much do you see this as a litigation strategy that can achieve judicially ordered remedies that make better policy, or to what extent is it more of the kind of political mobilization and focal point that Larry was referring to?
Yeah. I think it's some of both, honestly. And I think historically it's been more the acculturation. That is, hey, human rights are really important. Human rights are being violated by the environment. Therefore, we should pay more attention to the environment. In other words, it can have this kind of catalytic kind of effort. And in fact, I first got involved in this now a little bit over 10 years ago when I was doing pro bono work for the government of the Maldives, which is a very low-lying coral atoll or archipelago in the Indian Ocean that's among the most threatened countries in the world by climate change. They very much went into the human rights advocacy model thinking we need to put a human face on what's happening to us. We need to have people think about places like us instead of polar bears when they think about climate change. I mean, it's amazing when you Google climate change like images, like a remarkably high percentage of the images are polar bears on ice floes. And that is important. But if you're on the Maldives, you're like, we're on a freaking ice floe here, man, and no one's paying attention to that. So to a large degree, I think that was part of what was happening. Increasingly, though, and somewhat to my surprise, honestly, over the last 5 years, litigation is just exploding in this all over the world. So many, many, many more cases than I can describe have already been decided, and at the national level, how effective they are, again, depends so much on the factors that are unique to each country. I mean, some litigation actually is effective, some isn't. In response to your broader question about do we really want courts, like what's the proper role for courts to play here? I personally have never thought that a rights-based approach to environmental protection can supplant effective regulation. It just cannot. You can't have judges playing the role of EPA. But what you can have judges do is making sure that the procedural norms are obeyed, which they often aren't, making sure that the substantive norms are effectively enforced and complied with, which they often aren't. I mean, the problem in many, many countries in the world is not that the laws in the books are weak. They're not. The environmental laws are often quite good. You go to Madagascar or Mongolia or whatever, they have really good environmental laws. They are not enforced. And the people in that country absolutely know that. So this is one thing a human rights approach can say. It can just provide you more ways into a remedial system than you might otherwise have. So I don't think it's something, again, that can supplant or replace regulation, but I do absolutely think it's something that can spur regulation. The Ashtar Lagar case is a good example. Just as you said, the Pakistani court did not tell the government of Pakistan, you have to reduce greenhouse emissions by this percentage. It said instead, it basically asked the government, what are you doing to actually fulfill this climate change adaptation plan? And the government was like, we don't really know. We think that agency is, or maybe that agency. The court said, all the agencies come in. I'm now appointing all of you to this committee, and you're going to report back to me in a month and tell me what you're doing. Even in the Urgenda case, the really brilliant thing about that litigation was that the Urgenda lawyers, a guy named Roger Cox in particular, came up with this strategy of saying, we're not going to ask the court to second guess what the Netherlands should be doing. We're going to take what the Netherlands government itself has said it should be doing in order to meet the targets it has told the world it plans to meet, and simply tell the court, using their own evidence, they're nowhere near meeting those targets based on their own policies. So in a lot of ways, it was simply an argument that you should do what you've said you're going to do. That's a pretty that's something I think courts are much more comfortable doing than if you go into a court and say, well, we think that the concentration of sulfur dioxide in the atmosphere right now, it's 0.12, but we think it should be 0.008. I mean, that's not something a court's going to want to get into. But if you say the government tells us that it's going to do X, Y, Z, it's been 10 years, it hasn't even started to do X, that's something courts are much more comfortable with. And I think that's one thing a human rights approach, not the only thing, but the one thing a human rights approach can do. More questions? Yeah.
I was wondering if you could explain further why the U.S. is so opposed to the environment. Maybe like everyone else knows that already.
Well, that's a good question, because this is not, you may think of this as, the Trump administration, they're evil bad, which they are, but this goes back a long way before that, right? I mean, this has been essentially a bipartisan position of the United States. I have a chapter on this in this book I'm working on. I have come to the conclusion that more than anything else, and more than what the U.S. says the reasons are, what it basically comes down to is the U.S. has never gotten comfortable with economic, social, and cultural rights, and it sees this as another big, frontier of economic, social, and cultural rights. I spent a lot of my time as a rapporteur trying to show that it's not just all about economic, social, and cultural rights, but I think for a lot of it, that's what the U.S., the political and legal decision makers in the U.S. government in both parties just don't really buy that it makes sense to talk about a right to an adequate standard of living or a right to health. I'm not saying no politicians do, but as a kind of mainstream, that's just never caught on. If it did, I think we would see a different approach really quickly. Do we have time for one more? I know you have other cases. Yeah.
I want to ask you about the extraterritorial obligations and the current situation of it, because it doesn't seem to me there's any binding sources of law in terms of like customary international law or domestic principles.
Right. So it's hard to answer this briefly, but I'll do my best. So this is, in many ways, human rights law kind of, in this area, expands on what international environmental law already did. But in this way, you put your finger on something that international environmental law is much stronger on than human rights law. So international environmental law basically has been built up from the idea that states should, conduct their own policies in ways that don't cause environmental harm to other states. It's just kind of state-to-state good behavior, good neighborliness, right? The Sic-ut principle, or Principle 21 of Stockholm. Human rights law just hasn't developed that way. Human rights law has been all about what governments owe to their own citizens. And so while human rights experts and bodies and the treaty bodies that oversee the Covenant on Economic, Social, and Cultural Rights, for example, have for quite some time now tried to build up this idea of extraterritoriality, many governments, especially in the global north, are still very reluctant to accept it because they're afraid of where it might go. And so in this context, I decided as a special rapporteur not to try and take that head on because it was extended so far out the environmental context, so far beyond the environmental context to all kinds of other things, and instead try and focus on this idea of international cooperation, which is more widely accepted. And I think I had some success with that. But I agree with you that the extraterritoriality is still a problematic issue, let's say in human rights generally, and in ways that have real consequences for environmental issues in particular.
Okay, we are out of time, but thank you so much for coming.
Yeah. No, it is.